crystallization. So we have fertilization, we have reading down, and now we've moved to crystallization. Because India wrongly suggests, I'm sorry to say, that the preamble to the VCCR crystallized prevailing customary international. It didn't. On the contrary, what did it say? The rules of customary international continue to govern matters not expressly regulated by the provisions of the present convention. And then we move to the relief sought, review and reconsideration. The court was treated to an interesting exercise in distinguishing and negating judicial precedent. We're all familiar with the basic proposition, one hopes, that a judgment of a court is binding until a superior court states otherwise. But the position that was advanced by India yesterday, I say again with respect, unabashedly, was that Pakistan was not relying upon the recent judgment of the Peshawar High Court dated 18th of October 2018 in the Abdul Rashid case. Well, of course, it hadn't been an annex to the counter memorial of December 2017, and it hadn't been an annex to the rejoinder of July 2018 for one very simple reason, because Pakistan understands chronology. Whilst documents headed secret can be backdated, the reality of the matter is that this judgment was handed down on the 18th of October 2018, and it's publicly available. It's a 170-page judgment, and we had no qualms about bringing it to the attention of the court in my written submissions. But in fact, what India said yesterday was that Pakistan has not offered an explanation to the court as to why these are the words that were used yesterday, my written submissions identify the passages in the transcript, and I'm driven to have to draw these to the court's attention. I wish I hadn't the duty to do so, but I do. And it bears heavily upon me, but I must discharge it. India asked why Pakistan had not offered an explanation to the court as to why Pakistan, did not rely upon the judgment if it supported its case. And I must confess that's a bizarre proposition, because it would appear that this is a proposition that can only be advanced if, with respect, India had closed its eyes as well as its mind, because the very screen that I'm looking at right now gave clear and express reference to the judgment in the PowerPoint presentation, and I made sure, unless I've acquired salinity over the past 24 hours, that I made reference to it in my oral submissions. India didn't stop there. India further asserted that Pakistan was concealing. Use of the word concealing. It's a very heavy word. I'm told that I should be very careful about the words that I use, but it seems that it's okay, it's all right, it's acceptable. In fact, it's justified for India to say that Pakistan was concealing the fact that the Islamic Republic of Pakistan had filed an appeal against the Peshawar High Court decision. Now, with respect, when the court looks at the slides that were before the court, page 48, second bullet, the court will see that that slide made express reference to the appeal pending before the Supreme Court. But yet, what's Pakistan supposed to do even now? I'm supposed to stand on a platform and maintain a position of studied moderation, whatever that means. When a sovereign state is being accused of concealing a fact, I'm supposed to stand here and say to the court that I agree I should maintain a position of studied moderation. Well, I can tell the court one thing, that what Pakistan has maintained throughout these proceedings is dignity, in the face of contumelious conduct on the part of India, which I'm driven again to remind this court of. What Pakistan has not done is allow itself to be provoked by tactics which are unbecoming of a state that identifies itself as the world's largest democracy. And in fact, the linguistic gymnastics that India has to engage in are of its own creation. Why? India said the following in its reply on the 17th of April 2018, that Pakistan, a sovereign state, did not have a procedure by which a trained independent judge. Now, I just pause there to see the nature, the startling nature of that proposition, that Pakistan, a sovereign state, did not have a trained independent judge, not a single one of them, who was able to dispassionately review the findings of a military court. That not only do they not have a single trained judge who is independent, but this individual is incapable of being dispassionate. Well, I'm sorry to say, as I said on Tuesday, that I would hope in due course the relationship between these two states can be one based upon comity, upon amity, with less heat, more light, more cordiality, more substance. But what's very clear is that the Peshawar High Court was able to address the questions before it, evidencing legal acumen, evidencing robust independence, evidencing objectivity. Indeed, the Peshawar High Court decision chimed with the observations of the experts, because the experts had clearly stated on the 28th of November 2017 that the High Court of Pakistan possessed an effective review and reconsideration jurisdiction. So having said that Pakistan didn't have a single trained, it seems, independent judge who was able to set aside his or her prejudices to dispassionately review the findings of a military court, now that there is the Chief Justice of the Peshawar High Court, no less, sitting in a divisional bench with another High Court judge, what's the solution? Well, the solution that India has turned to on more than one occasion, to say, but the judgment has no value. It's irrelevant. Why? Because it's the subject of an appeal. Again, in all legal systems that I'm familiar with, civil law, common law, a court's decision is valid until declared otherwise by a superior court. Otherwise, the whole nature of precedent and legal findings would be thrown into chaos. But not in this case. In this case, what we're told is, let's ignore the decision of the Peshawar High Court. It has no value, it's irrelevant, because it's subject of an appeal. Does that mean that parties aren't entitled to seek appeal? Does that diminish the existence of an effective review and jurisdiction, effective review and reconsideration jurisdiction in the High Court of Pakistan? How can it? And then we move beyond that by way of the materials that India served in its reply yesterday, a large file of documents, part and parcel of the scattergun approach of deflection. A problem arises for India, namely this, that India referred to a recent European Council resolution, even assuming that that had any relevance in this context, to assert that this resolution explicitly, now again, so far as I'm aware, the word explicitly means expressly, clearly, reflects concerns at the conduct of certain states in which Pakistan figures prominently. Now, my understanding of English, my simple understanding of English, tells me that to figure prominently means to be in amongst a list, but to have your presence accentuated, to have your presence drawn attention to, with regard to due process of law and fairness of trial. However, I regret, despite having read paragraph 9 several times, in the early hours of the morning as well, and recently, as opposed to what no doubt India will say was India's interpretation, it shows no such thing. There was absolutely no explicit or underlying reference otherwise with regards to due process of law and fairness of trial. So why use language such as explicitly, figures prominently? Is this part and parcel of what I said to the court on Tuesday? Is it a mindset of catch me if you can? And so far as the military courts are concerned, I ought to make it absolutely clear that notwithstanding the experts' report, notwithstanding the availability of effective review and reconsideration before the High Court pursuant to the Constitution of Pakistan, it is simply wrong for India to disparage the military courts of Pakistan as it has done. The rules of evidence and procedure are the same as in the civilian courts, with evidentiary standards, procedural rights, and the capacity to grant relief being substantively the same. The confession that is adduced as evidence in the military court is recorded under Section 164 of the Code of Criminal Procedure before the judicial magistrate in the manner as provided in the Code of Criminal Procedure and in accordance with the standards that apply otherwise. Indeed, the very same magistrate is called as a witness before the military court to give evidence as to the confession that he or she took. A confession that's taken in accordance with stringent safeguards. Now, India, with respect, is seeking to misrepresent the military courts of Pakistan. Not a single juvenile was tried and convicted by the military courts. And it's important to remember that Commander Jadhav was tried and convicted pursuant to Section 3 of the Official Secrets Act of 1923, which provides for jurisdiction in respect of espionage offences. He wasn't tried and convicted pursuant to the extension of the military court's jurisdiction in 2015, brought about as a result of the appalling atrocity whereby innocent children were massacred in a school in Pakistan, in Peshawar, more than 100. That's what prompted the extension of the jurisdiction of the military courts. And the carnage that has ensued in Pakistan over the past 10 years, which has been abated because of the considerable efforts and sacrifices of the forces of Pakistan, is a carnage that many of you on this bench and many in the room will be all too familiar with, and some have suffered personally themselves. So it's absolutely wrong, I would say improper, to have sought to castigate the courts of Pakistan in the way that India has done, to suggest that there's not a single trained independent judge who's capable of dispassionately reviewing the findings of a military court. I mean, that's what it comes to when you boil down the proposition. So I move, finally, to my concluding observations. And as I said in the counter memorial, and I apologized in the counter memorial, I apologized that I would have to use trenchant language, forceful language, that I was being compelled to use forceful language. It's not ordinarily the case that I use forceful language, but sometimes situations demand language is used because it's necessary to convey the essence of the situation. Indeed, that is what language is meant to do. It is meant to enable us, with precision and accuracy, to convey. And it's meant to carry, with precision and accuracy and objectivity, meaning and effect. But the brazen distortion of the 2008 agreement and the doctrine of the military experts' reports were matters that even at the commencement of the oral phase of these proceedings, however incredulous it may seem to some, Pakistan was expecting India to show some respect, at least to the court, and if not to Pakistan, at least to the independent experts. An apology would not have gone amiss. That has not happened. And so we are here now in a position, so far as India is concerned, which is as devoid of legal merit as it was on the 8th of May 2017. In fact, even more so in the light of India's continuing conduct. I'm sorry to say, I regret to say, but I am compelled to say. And India's claim for relief remains as far-fetched now as it was then. And all of these matters are important because this court, the International Court of Justice, the World Court, stands at the apex of all judicial institutions. This is the court that provides the touchstone for conduct of states as amongst themselves. This is the court that sets the ground rules pursuant to which states engaged mostly decently and identifies, however reluctantly, when states have behaved indecently, because it's a difficult conclusion to draw. It's bad enough having to conclude that an individual has behaved indecently or abusively, let alone a state. But sometimes, very rarely, Sometimes, nevertheless, it's incumbent upon an adjudicative body to identify the facts and see them for what they are, and express its position clearly, not just for the litigants in the particular case, but for the future, because the rule of law depends upon it. India's conduct has shown contempt for accuracy, I'm driven to say, and I've shown the examples. Its conduct is replete, even yesterday, and a total disregard for the truth, I'm sorry to say. But I'm not sorry to say the following. And I say it, as I said on the 15th of May, in the context of the Provisional Measures Order, and I say it again. India's claim for relief must be dismissed or declared inadmissible. Mr. President, thank you.
I thank Mr. Qureshi for his statement. I shall now give the floor to the agent of Pakistan, Mr. Anwar Mansoor Khan. You have the floor, sir.
Your Excellency, the President of the International Court of Justice, the Honorable Judges, before I start my closing statement, I must say that I'm extremely happy that Mr. Gilani has recovered and is able to attend to this court. At the close of the case, I would, as agent of the Islamic Republic of Pakistan, bring forward some crucial issues which are raised and were irrelevant to the case in hand. Very strong, uncalled for criticism has been made on the judicial system of the Islamic Republic of Pakistan in an attempt to show that it has no review or reconsideration process. Pakistan has a very robust judicial review and reconsideration system. May I say that the entire courts, whether regular, civil, criminal courts, special courts, specialized tribunals, or military courts, are created through various acts of the Parliament as prescribed by the Constitution. The proceedings before any court are in accordance with the criteria specified by law, in force, and that it is true as to the procedure prescribed by law for trial before the military courts. Naturally, for reasons of state security, confidentiality, state secrets, some of the trials cannot be made public. This is true in almost all jurisdictions, including India. Article 4 of the Constitution of the Islamic Republic of Pakistan provides that every person shall enjoy the protection of law and no action detrimental to his life, liberty, body, reputation, or property shall be taken except in accordance with law. And Article 10A of the Constitution of the Islamic Republic of Pakistan gives as fundamental right the right of fair trial without it being subjected to any law, where many other rights are subject to law. Thus, fair trial is an absolute right and cannot be taken away. All trials are conducted in that manner, and if not, the process of judicial review is always available. Mr. President, and the honorable judges, I need to remind my friends of the case of Afzal Guru. He was refused a lawyer, and the court appointed a lawyer, filed an application stating that Afzal wanted to be killed by a lethal injection. It is amazing that the Honorable Supreme Court of India, while absolving him from the charge of being a terrorist organization, but to satisfy, and I quote, the collective conscience of the society, upheld the death sentence. I asked them, is that a ground for conviction under the law or the Constitution? This is a fair trial in judicial review in India. Mr. President and honorable judges, I did not want to bring in the various contentious issues of India, but for unwarranted and concocted allegations. I need to make a mention of the Samjhauta Express. Terrorist acts where more than 42 Pakistanis were burnt alive. Pakistan has requested that the perpetrators be brought to justice, but no action has been taken. India has embarked on the process of exonerating the accused who have confessed to the carrying out of the heinous act. Families of thousands of Muslims of the Gujarat who were massacred in 2002 with full state connivance await justice. When we talk of the unfortunate incidents of Pulwama in India-occupied Jammu and Kashmir, India has become a judge, the executioner, and call themselves the victim. Without any evidence to show or any inquiry held, Pakistan has the right to ask for proof, to which India has no reply. May I now only refer to the atrocities committed by India without any recourse for victims. The Indian human rights have been targeted, have been a target all over the world. The Indian human rights have been targeted all over the world, and may I mention the use of pellet guns by Indians on innocent citizens of India in the Indian-occupied Jammu and Kashmir, where more than 200 innocent civilians have lost their lives, more than 15,000 have been injured, and more than 15,000 missing. More than 2,000 innocent men and women have been blinded for life by use of pellet guns. This includes 18-month-old Hiba, who would never be able to see in her life. Do we forget the rape of the young 8-year-old Kashmiri girl, Asifa Bano, of Rasana village in Katog? The UN report asked for inquiry, but of no avail. We also cannot forget the soldiers of 4 Rajputana rifle regiments having raped 23 women in Kanun, Pushpara village of Kupwara district of the Indian-occupied Jammu and Kashmir. Attempts to seek justice was denied by the authorities and the judicial system. According to the Human Rights Watch, the Indian Army courts of inquiry dismissed all the charges against 5 officers for the high-profile killing of civilians in India, Indian-occupied Jammu and Kashmir, demonstrate the Indian occupation forces' continuing impunity for serious abuses. On 24th of January 2014, the Army said that it was closing the case for lack of evidence against the army officers who were accused in March 2000 for extrajudicial killing in Chittagpura for 5 civilians and falsely claiming that the civilians were terrorists who killed 36 villagers. The army blocked the case after it used the Armed Forces Special Power Act 1958 and was invoked to block the case brought by the civilian Central Bureau of Investigation. India relies on the report of a private NGO, International Commission of Jurists, to discredit Pakistan. There are numerous reports of similar nature from the public domain against India. Some of them have been filed and available on the judge's folder. The findings of the private organization are being put forward to challenge the report of the qualified experts filed by Pakistan. The report filed by Pakistan is plausible and correct. The report of the Commission is unfortunately biased. I have dozens of other examples of lack of judicial review in the Indian judicial system. I need to explain that the judgment of the Peshawar High Court, which was rendered under Article 199 of the Constitution of Pakistan, the judgment of the Peshawar High Court allowed the petition on grounds of facts available were not sufficient to convict the 72 persons. The appeal to the Supreme Court was on the facts and evidence before the High Court, which was not fully appreciated by them. May I say that the military courts of our country are governed by the Constitution and by all statutes, including the laws of evidence, the Criminal Procedure Code, and all similar laws. Thus, saying that the military courts are for some reason incompetent and above the law is an incorrect assertion. I would also make it clear that the said Commander Yadav has been charged with terrorism for which a FIR has been registered with the police, that is a civilian agency. The military courts have sufficient proof of espionage, and the said military courts on the available evidence and the judicial confession proceeded to convict him, despite he being given the option of going for a judicial review. He has refused to do so. May I, Mr. President, and the honorable judges say with full authority that the system of judicial review in Pakistan are potent and very effective. The courts of law are extremely independent, only act on facts and the law without being influenced by any extraneous reasons. India claims consular access, surely was not allowed for good reason in terms of the agreement of 2008, especially for the reason that Commander Yadav being involved in espionage. He was allowed to choose a lawyer for himself, but instead he opted to be represented by an in-house counsel, defense officer, qualified for legal representation. Should he choose to enter into the domain of judicial review, he will have the right to choose his lawyer to represent him. I am the chairman, sir, of the Pakistan Bar Council, the highest body of the lawyers of Pakistan. I say that there is no resolution of Pakistan Bar Council to the effect as passed by the Lahore High Court Bar Association. The said Bar Association passing a resolution is within their own body. However, the Pakistan Bar Council is for Pakistan and overrides all bar associations. Mr. President, and the honorable judges, India seeks relief which they cannot claim from this court. Seeking to release Commander Yadav, allowing him to proceed to India, or a direction of review and reconsideration. If it is the choice of the convict to seek a review and reconsideration. It is the choice which, if he seeks, will be given to him. I surely want to bring forth the fact that there is an FIR against him in the civilian domain, and that, in addition to the conviction so given, the case of terrorism is to commence against him. In addition, such a relief may not be allowed. Naturally, maintaining the judgment is essential till it is set aside by a court of competent jurisdiction in a judicial review proceedings, which he is advised to take in Pakistan. And finally, sir, the Islamic Republic of Pakistan respects the court for reasons set out in the Pakistan's written pleading and in its oral submissions made in the course of these hearings to declare India's claim inadmissible. Further, or in the alternative, to dismiss India's claim in its entirety. Mr. President, distinguished members of the court, to conclude our participation in these proceedings, I wish to extend on behalf of the Republic of Pakistan our sincere appreciation to you, Mr. President, and each of the distinguished members of the court for their kind attention to our presentations. May I also offer our sincere thanks and appreciation to the court's registrar, to its staff, to the interpreters and the translators, and to all the court staff who have worked hard to ensure the smooth running of these hearings. Thank you very much.
I thank the agent of Pakistan. The court takes note of the final submissions which you have just read on behalf of the Islamic Republic of Pakistan. This brings us to the end of this week-long hearings devoted to the oral arguments in the case. I would like to thank the agents, counsel, and advocates of the two parties for their statements. In accordance with the usual practice, I shall request both agents to remain at the court's disposal to provide any additional information the court may require. With this proviso, I declare closed the oral proceedings in the Yadav case. The court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the court will deliver its judgment. As the court has no other business before it today, the sitting is now closed. Thank you.